zero court filings, total control. Why private trusts just work. I was trying something new. Sorry about that. Listen, when it comes to trust, the biggest thing that I want to get across, I guess the biggest point that I would like to get across is that these are private structures. What you understand as what we know as the individual entity, the LLC, the corporation, the partnership, these are all structures that owe their existence to legislative authority or state authority. But there are other structures. There are. So we're going to get into that in this show. Don't want to take up too much of your time. My name is Sot L, Seeker of Truth L, Speaker of Truth L. This is the foundation where we understand incorrect information incorrectly applied can get you hurt. Correct information incorrectly applied can get you hurt. So as always, we are looking to correctly apply that correct information here at the foundation. We are having a wonderful time. Do want to announce my life is good. Oh, what was it? We have the winner. You know what? We're going to see if we can get a hold of the winner. We're trying to give away AirPods and an iPad mini. I've never had such a difficult time giving away stuff. But we got a new winner for the AirPods. We're going to contact the winner first, see if the winner contacts us back. Then we will announce them. Then we can give away the iPad. Of course, we trust that you will invest in your private education with these devices. But ultimately, nonetheless, it's up to you what you do with these things, you know what I mean? So, welcome to the foundation. It's been a week or so. I apologize. I have things going on, and it's private. I'm not even gonna lie. It's in private. I wish I could share it with you guys. I really do, but I can't. But when things have been, when they've been concluded, I will drop some breadcrumbs. Listen, I'm excited. That's all I can say. It's pretty much off topic of the foundation here, but look, say less, right? That's what you want to tell. I hear you. I'm saying less. Let's get into the show then. 100%. Make sure you check out welcometothefoundation.com. Make sure you check out the email list. Sign up for it right here in the little bitbox. Primary email. Just put it in there. Hit next. It says you got to, you're going to get an email. You got to confirm. That's not true. Once you put it in there and hit next or hit the arrow, you're doing your dance. I promise you. It goes into who we are. You can make a donation. It goes into what we do. You can make a donation. It goes in why we do it. You can follow us. Our services, so on and so forth, our education that we offer. I like to tell people to start with this right here. Foundation Trust Primer. I have people ask me, hey, so I really respect where you are with regards to your knowledge base regarding trust and contract law. How do I, where do I start? I want to know what you know. Where do I start? I got that question a lot. So this is it. This is the answer to that question. It's called the Foundation Trust Primer. It's over 18 documents handpicked by yours truly, me, Sot L, Seeker of Truth L, with that question in mind. So there it is. We also have the Foundation Trust Series, Part 1, Part 2, and Part 3. I would say beginner, intermediate, advanced, just to get your mind right. Those three, the Foundation Trust Series, they are shipped to you physically on digital video discs, DVDs. That's just the way it's done. So if you don't have a DVD player, you got to get one, player. But that's how it's done. You can watch it over and over and over and over again. Even if the website goes down, you still have it. Just watch it over and over and over again. And then if you so choose, afterward, moving forward, you can, sign up for trustee training. The link the link is in the description. Wow. It's one of those days, huh? We teach trust administration. This includes, creating and administering trusts. Obviously, there are educational materials, quote, end quote, educational materials. We do not sell trusts. Does that make sense? Link in the description. The most comprehensive trustee training available, period. Hands down. Learn at your own pace. No tests. There's no quizzes or anything. There's no way that you're really going to be embarrassed, Learn at your own pace. I know people work. People have families. This stuff is important, though. And, excuse me, like I said, we don't sell trusts. No, but educational materials are included. You hear me? You hear me. How to start a business. If you want to start a business, we suggest that this is something that you do. People use LLCs. Some people will use trust. Doesn't really matter as long as you start doing a dance. The structure, whether public or private, it's up to you. 100% up to you. I tell people, what's the difference? Well, if you are looking to establish business credit, you know what I mean? If you want, the business credit, you're not gonna achieve that in a situation with a private trust. Doesn't happen. I've tried it. There's some other considerations as well, but I would say that that's the main one. Excuse me. Would be, if you're looking to establish business credit. But, I think every family should have at least one family business. It may be up to you to start it. So link in the description if you're interested with that, with regards to that, as well as with the, trustee training. So today is, zero core. Listen, we just want to tell you. I just want to tell y'all what it is, right? So I use public available information. These aren't my documents. This isn't my stuff. This is Daniel S. Pickens' law. Now, I don't even know who this guy is. I did a Google search. No, it wasn't. I don't use Google. I'm sorry. And Google isn't a verb. It was a internet search, but I did not use Google. And the question really is, do you have to register your trust with the state? Many people wonder if they need to register their trust with the state. Trusts generally, I want to say generally do not require registration with state authorities. Unlike corporations or LLCs. Look, it's a little glimpse into what I was saying. There's private structures and there are public structures, those structures that owe their existence to legislation or legislative authority. This means you can set up a trust without filing paperwork with your state government. And then it says in most cases. And in these most cases, we get into them. We define a trust. A trust is a legal arrangement where one party gives another party the right to hold assets for the benefit of another party, known as the beneficiary. So you got the grantor or trustor or settler. You have the trustees or trustee, and you have the beneficiary or beneficiaries. It's a 3-party contract. Trust serve many purposes. They can help avoid probate, reduce taxes, and protect assets from creditors. Some trusts also provide for minors or family members with special needs. Okay? There's different types of trusts. Irrevocable. Then you got revocable. The IRS recognizes 3 different types of trust. This is a caveat. I don't know if you're taking notes. Probably not. But if you are, hey. Simple, grantor, and complex. That's really what matters when it comes to taxation. Federal taxation. These types of trusts, they're not registered with the state. There's different state variations. Some states say that trusts have to be registered. generally, these are going to be trusts that are set up by attorneys, and it's the jurisdictional element that is within the trust agreement or trust contract itself. I just want to tell you guys that states that require trust registration often do for several reasons. First, registration helps protect beneficiaries by creating a public record of the trust's existence. This can prevent fraud and ensure proper management. Additionally, registration allows courts to monitor trust administration more effectively. And listen, we're talking about statutory trust or statutory governed trusts. These are the trusts that we learn about in trustee training. But even public trusts generally don't have to be registered. Let's move forward from here. Look, U.S. Legal, uslegal.com. Does the trust need to be filed? I'm considering using the uslegalforms.com for completing a living trust. Wouldn't recommend it over here. We don't recommend those. Those are revocable. And we'll jump into that in a little second. Do I have to file the completed documents with the state or county agency? Answer: a trust document isn't required to be filed. If you are transferring real estate into a trust, a deed will need be filed. I think that we all know that's two. A deed will need to be filed at the county recorder's office. A trust is a private document, but sometimes the county recorder will allow filing, so you should inquire for local procedures if you have a reason to want it on file. You see that? If you have a reason, I like how that was phrased. If you have a reason to want it on file, do what you got to do. Let's get into this one. Tax Shark. This one's, I like this one. Got it from a web search though. This is recent, March 2025. Generally, no trusts are not registered with a state agency in the way that corporations and LLCs are. You see this? This is common. Corporations, LLCs. In the United States, a trust is a private legal arrangement between the person who creates the trust, the person or institution managing the trust, and the beneficiaries who will benefit from the trust. Unlike a business entity, you do not file a trust agreement with the Secretary of State, y'all, or the county, either y'all, you don't, or any central registry to make it valid. Simply signing the trust document, often before a notary and witnesses, depending on state requirements, is enough to create a legally enforceable trust. Federal law, there is no federal registry of trusts. People have asked me that too. I got a federally registered trust. How? How do you have a federally registered trust? How? How did you do that? That's amazing. At the federal level, trusts are recognized through tax identification, EIN, y'all. People are like, well, I got my 9-8 number. Do you believe that's a federal registration? Or is it an employer identification? But no federal law requires a trust formation document to be recorded or registered in a national database. In fact, trusts have been used for centuries under common law principles, and their validity does not hinge on any government approval stamp. Look, man, and people, sometimes if I show you where other people say what I'm saying, it hits harder. It's sad but true. I'm not lying. I accept it. I feel like as long as the information is received and comprehended, whatever, man. It's not an ego dance. Like who taught you that? I really don't care. Does not hinge on government approval. Any government approval stamp. State law. Most states do not require any registration or filing for a typical living trust or family trust. Trust law is state specific. State specific. They're telling you it's under state statutory law. It hinges on the jurisdiction that is identified in the contract. You have to understand, this is why you need trustee training. There's no single national trust code, but the vast majority of states treat trusts as private documents. They're private instruments. When you establish a revocable living trust, don't do it. Don't do that. But don't listen to me. I can't give legal advice. I don't know what I'm talking about. I'm crazy. I'm out of my mind. For example, you keep the signed trust agreement in your records and perhaps share copies with trustees and advisors, but you do not submit it to court or state office. If there is an action, you can file an action, and generally that's going to be a beneficiary or it's going to be another trustee. And yes, there has to be a memorandum of trust or some sort of certificate of trust that's filed with the court. And then the portion of the private contract, not the entire thing, the portion of the private contract that speaks to the issue. So if there's 14 pages, this should only be like half a page, man. If that. Sometimes it'd be the full page. But what I would say is, why is there so much language? Why would you need a full page to treat the specific subject matter that is at issue? I've seen it, but it's rare, and I'm like, what? People just be trying to sound smart. They be typing and just be like, oh, I'm just exceptionally brilliant over here. So do not submit it to a court or state office. The privacy is one of the attractive features of trust. Unlike a will, which becomes public through probate, a trust can remain confidential. Did y'all know that? Most people don't. The exceptions, a handful of U.S. states have adopted laws often based on older provisions of the Uniform Probate Code or their own trust codes that provide for trust registration with the local court. Even in these states, however, the requirements are minimal and lack serious penalties. Typically, only 3 states explicitly require trust registration by law, which is Alaska, Idaho, and Kentucky. And several others allow or encourage registration, such as Colorado, Michigan, and Hawaii. I mean, yeah, you can't listen. They can't. No, I don't listen. Not one of the several states of the union can require registration of a private trust. That's why there's no requirement. Now, they can encourage the registration, and depending on jurisdictional elements specifically, the jurisdiction that is cited in the trust indenture itself. Like they're going to say, what is the situs of the trust? What is the jurisdiction of the trust? Can you substantiate that? That falls outside of state statutory law. Bottom line, for most people creating a trust, there's no need to register your trust. What happens if the trust isn't registered? No registration, no problem. Trust is still valid, even if the state that's require registration. Not registering does not invalidate the trust, y'all. The trust agreement is a binding legal instrument once it's executed, according to state law. This is according to common law. They set it up there, too. So you got state law, you have common law, you have contract law. You have international law, you have treaty law. Potential penalties. Technically are authorized, some states technically authorize penalties or sanctions against the trustee who fails to register. For instance, the court could remove a non-compliant trustee or deny them compensation. Okay, so the court would have to have jurisdiction. There's a jurisdiction. Oh, wait. Court jurisdiction concerns. The main reason states have trust registration at all is to establish which court has jurisdiction over the trust. Let me know. Let me know if I'm lying. But if you register the trust with the state automatically gets jurisdiction. Doesn't matter what jurisdiction is invoked in the contract. I'm not playing. Doesn't matter. Tell the truth. If it's trust is registered in state X, then state X's courts are confirmed to handle any disputes or supervision of the trust. Then they can listen. You're not a trustee anymore. The court, gavel. Sustained, gavel again. Overruled. I don't know. I'm just being weird, but they throw the gavel down and boom, you're no longer trustee. You got to walk out and give all the access up, sign over the accounts, and look what. Without registration, there might be a debate over the proper venue for a trust. If y'all know what a venue is, jurisdiction and venue for a trust dispute. However, the proper venue for a private contractual trust dispute is equity. You hear me? It's equity. It's equity. Even if a trust isn't registered, generally the court in the state where the trust is administered or where the trustee resides, this is how they, be trying to get jurisdiction. And that's why some people say, hey, the trust isn't private unless the grantor, the trustees, and the beneficiaries are private. I disagree, but that's a strong point, because if there's any weak link in the chain, whether it's grantor, trustee, or beneficiary, jurisdiction can be granted at any time. However, I already said that. Registering just makes that choice of forum official and clear. If you fail to register in a state that expects it, you could face a scenario where a lawsuit is brought in a less convenient court, but this can often be rectified by subsequently registering and asking to transfer the case to the home state court. They remove it to a different court. Happens all the time. Okay, so what else we got? Type of trust and the registration requirements. Revocable living. These are the ones. No public registration, maximum privacy. I don't believe that. Don't believe that. These are state trusts. They start talking about registration requirement. Nearly all states do not require you to register a revocable living trust. In fact, forcing registration would undermine the privacy advantage. Right? You draft the trust document, you sign it, and that's it. No trip to the courthouse or state office needed. That's it. Did you guys know it was that simple? Irrevocable trusts. Private agreements. Irrevocable trusts are trusts that generally cannot be changed or revoked easily once created, except as allowed by their terms, right? That's private. Or court order. That's public. And there are irrevocable private trusts and there are irrevocable public trusts. Yes, there are. But if they're talking about the terms of the trust, that's private. You're talking about court order, that's public. These might include irrevocable life insurance trusts or ILITs, asset protection trusts, or trusts set up to make gifts that get assets out of the grantor's estate. Since the grantor relinquishes control, these trusts stand on their own during the trust terms. And that's the main part. The grantor relinquishing control. That's what makes it irrevocable. Revocable means the grantor has control. Irrevocable means, irrevocable, grantor is out of here. Can't do anything, has no say, doesn't matter. Trustees, once the trustees sign on to the trust as trustees, grantor is pieced out in every way, shape, and form. And that's why I'll be wondering, we in trustee training, you're learning how to be a trustee. I get it, because there's other ideologies in people's minds where, they're the beneficiary, or they believe they're the beneficiary, or they believe they're the grantor, or they're paying. I get it. But listen, don't mix public and private. We are talking about private trusts over here on the foundation. Private agreements. By and large, irrevocable trusts are not subject to routine registration with the state. They are also private documents. The same state law principles apply. If you're in a state with no trust registration statute, you simply execute the trust and manage it without any state filing. If you're in one of the few states that does have a registration provision, technically the trustee should register the trust with the local court as described by the state's procedure, usually filing a statement with the basic trust info. Notably, some states expect registration of trusts that are administered in that state. So if you set up a Delaware asset protection trust, but you live in Pennsylvania, you wouldn't register anything in Pennsylvania. Delaware doesn't require registration either, so the trust stays off any public registry. Understand what I'm saying? They get into some other things, charitable trusts. Bottom line, no court filings. We got some common pitfalls when the trust registration becomes an issue. I wanted to read that. Assuming you must register a trust like an LLC, a frequent mistake is thinking a trust isn't real or valid until it's filed with some government office. People used to dealing with businesses or business entities often ask, where do I register my trust? Pitfall. This can lead you on a wild goose chase, sending your private trust document to a state agency that doesn't want or need it. Solution: know that for nearly all trusts, the signed trust agreement itself is sufficient. Don't waste time or expose private information by trying to record it publicly. Unless advised by an attorney in a specific scenario, and any attorney worth their salt is not going to tell you don't register it anywhere. You can file it in a case record. And that's with regard to a specific action. Regarding the trust deed unnecessarily. Recording the trust deed unnecessarily. Some well-intentioned individuals record their entire trust instrument with the county recorder as if it were a deed because they think it formalizes the trust. This is usually not required and not advisable. Pitfall: recording your trust makes all the terms and beneficiary info public record, undermining your privacy. It could also invite fraud or nosy relatives prying into your estate. Solution: if you need to show evidence of the trust's existence, for example, to a bank or title company, use a certificate of trust, which omits sensitive data. Only record documents that are meant to be public, like deeds transferring property to the trust. So there's a certificate of trust that's genuinely public. Those are like statutorily governed trust. You will also see memorandum of trust. Also, generally, open up a bank account. The bank will want the trustee to certify there's a trust under penalty of perjury. So I guess they call that a certificate of trust as well. But you have a certificate of trust. You have a memorandum of trust. You also have a short form. You have a trust short form. We rock with the short form. It's luxurious. I mean, it's one of them. Let me stop. Failing to notify such trustees and beneficiaries, that's a big no-no. Let them find out. Scams and misleading solicitations. Believing the trust has no oversight because it's private. Privacy doesn't mean lack of accountability. A trustee might think, since I didn't register the trust, no one is watching. I can do what I want. This is dangerous. Beneficiaries have rights. Trusts are enforceable in court even if unregistered. Mismanaging trust assets, even in a fully private trust, can lead to lawsuits, removal of the trustee, and personal liability for the trustee. Solution: always uphold your fiduciary duties as trustee. Keep good records and treat the trust professionally, even if no authority is actively monitoring. If disputes arise, they will come to light in court, registered or not. Equity. And, you can move a court to, equity, especially if you're talking about a contract, because, we don't want you to make a judicial determination upon the facts. You want you to enforce this contract. The contract says this. This didn't happen. The contract says if this doesn't happen, this, and this. This is what we're asking you to do. It's equity. It's not. There's no judicial determination. There's no. You don't have to interpret the contract or any of that. Everything is plain and simple. We can show a breach of contract, and we can show within the contract that there is a breach. The contract describes what a breach is. It describes this breach to a T, and it describes the penalties and the redress. This is what we're looking to enforce. To me, it's simple. California, I think there was something else I wanted to. Florida, blah, 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 New York, New Jersey, Michigan. Was it this one? Oh, here we go. Trust versus LLCs, corporations, private agreement versus state charter. Listen, and I do shows about this, public versus private, so on and so forth. Business entities like limited liability companies or corporations are creatures of statute, also known as creatures of the state, artificial persons. To create an LLC or corporation, you must register them with the state or government. LLCs are formed with articles of organizations. Corporations are formed with articles of incorporation. Without this state filing, an LLC or corporation simply doesn't legally exist. Public availability. Anyone can look up the corporation or LLC at the state's business registry. That's public. Ongoing compliance. Businesses usually must file annual reports, pay fees, and keep registered agent on file. Failure to do so can lead to administrative dissolution, the state revoking the company's good standing. Now contrast this with trusts. No state charter needed. It comes into being through a private agreement and the act of transferring assets to the trustee. In essence, the party's actions create the trust under the law without a state official stamping approval. Trusts are often said to be creatures of common law and equity. Remember when I said? That's the jurisdiction. We're moving for equity. Why is it equitable? Research. If you research for yourself, you will remember it. But you might, if you're like me, you won't remember where you read. I don't know where I got that from, man. It was just I know I read that, and I know I read it in more than one spot, and I know it's true because I shepherdized it and it stuck, but the reference didn't stick. Sorry. That's how you'll be. You'll be just that's why I say that all the time. Equity, not creatures of statute. In the way corporations are, trusts are not listed in public databases. Interestingly, a trust is not a separate legal entity in the same way as a corporation. So these are public trusts under statute because, legal and equitable title are split. So the trustee or the trustees have legal title and the beneficiaries hold equitable title. In a private trust, the title is not split. The trust itself is a separate and distinct entity, and it holds both abstract sides of the title. I don't know. Stuff is all made up anyways, man. Then you got, in contrast, there's a concept of business trust or statutory trust. See that? That's why people are like, we got the business trust. And I be like, listen, especially in trustee training, like, listen, we say business trust. We don't mean business trust. We just, we speaking amongst each other. We're talking about the function or the purpose of the trust. We're not talking about an actual business trust. A business trust is statutory. The Massachusetts business trust, the Delaware statutory trust. These are used in certain business and investment contexts because a trust is much more, it's much more, how about this? It's much less risky investing in a trust than it is investing in an LLC. You have more rights, contract rights. The state statutes can limit your rights with regards to a bankrupted LLC that you invested in. No state can impair the obligation of a contract, though. And here's the thing. People miss out that includes statutory contract trust or contract trusts that fall under statutory jurisdiction, and it includes private trusts that do not fall under state statutory jurisdiction. Both. But, statutory trust, That's a no-go. And then we have, what is this? Blah, blah, blahs. ESA law, another law, state taxation of trust. Where does the trust reside? State income tax implications. So 8 states currently have no state income tax. Those states are Alaska, Florida, Nevada, New Hampshire, South Dakota, Washington, and Wyoming. Of the states with state income taxes, whether trust is taxable is generally determined by one of the combination of following criteria. Okay, so you have to understand this. These are statutory trusts. These are trusts that are governed by state law. Okay? I'm gonna tell you how it goes. And then, you be administering a trust, it's private. And then the IRS, the state revenue department, will send the trustee, one of the trustees, or the trust itself, a document, a letter saying we didn't receive, your filing, your trust filing for, this year, so blah, 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 blah. You got, listen, most people don't understand there's options. Most people just pay and they, to do the blah, because, it's governed by state statute. It was set up by an attorney that they paid, and the attorney said that it's governed by state statute. This is, governed by the laws of the state of. That's the language you see in there. So, in this situation, you file the return and pay the penalties and so on and so forth. If it's truly private, like how we learn in trustee training, we simply rebut it and enforce the contract. Let them know the jurisdiction. And it's generally going to be a certified notarial copy of the specific portion of the trust indenture that speaks to the jurisdiction. Those are the two options, man. I mean, there's another option, but that's beyond the scope of this conversation. But those are the two options. Most people go with option one simply because they don't know. So, residents of the grantor, this is with the states that do, of the states with state income taxes, whether a trust is taxable is generally determined by one or a combination of the following. Residents of the grantor, situs of the trust, and jurisdiction, y'all, situs, jurisdiction, residency. That's a statutory term I just want y'all to know. Statutory. All right. Residency of the trust, residency of the beneficiaries. Of course. The states applying these factors further have varied income tax rates. All right, let me go down. Recent court opinions. This is what I want to talk about. Most recently, on July 18th, 2018, the Minnesota Supreme Court ruled their state's attempt to tax a trust to be unconstitutional. Okay, so the Supreme Court of Minnesota said that the Minnesota state attempt to tax a trust was unconstitutional when the relevant statute attempted to tax a trust if the trustee was a resident of a state on the date the trust became irrevocable. Okay, and there you go. There's a little, blah, blah. This is obviously the citation right here. It's a citation. McDonald versus Commissioner of Revenue. The facts of the case are that 4 irrevocable trusts were formed with the stock of a Minnesota S corporation. At the time, the trusts were grantor trusts created by a Minnesota resident. Eventually, the grantor relinquished. Remember, this made it irrevocable because he relinquished. He relinquished the powers that caused the trust to be a grantor trust. So that made the trust irrevocable. Remember that. During the year at issue, the trustee was a Texas resident and the trust sold their interests in the S corporations. That's why the Minnesota Revenue came after them, because they saw it. They was like, oh, these trusts made a bunch of money. Oh, they sold their interest in this Minnesota S corporation. So these Minnesota trusts sold their interest in this. Well, we got a tax. We got money coming, right? You follow? During the year it issued, the trustees was blah, blah, blah. I said that. 3 of the 4 trust beneficiaries resided outside of Minnesota. Okay? The trust argued first that the only issue to be considered is whether the statute only requiring a Minnesota grantor is constitutional. Okay? That's a good question. The trust further argued, and you see how they say that trust, because a trust can sue and be sued in its name. Okay? So the Minnesota Revenue, the Commission of Revenue for the Minnesota Revenue, sued the trust in the name of the trust because the trust was the one that had the money in its trust account from the sale of the stock, the S corporations. Sold their interest in the S corporations, right? So the trust had a trust account. Listen. And so listen, they're legal and separate entities. Okay? The state argued that the trust were formed in Minnesota by a Minnesota resident using a Minnesota law firm, held stock in a Minnesota S corporation. Remember I said the law firms, the attorneys are always, 99% of the time, they're going to put the jurisdiction under the state. 99% of the time. Okay? Held stock in a Minnesota S corporation. And listen, they know that. They know that. That's how the states get jurisdiction. They know that. They know. They already know. If it's set up with a law firm, we're in here. Held stock in a Minnesota S corporation were governed by Minnesota law and had Minnesota beneficiary. Ultimately, the court disagreed, though, with the trust's desire to limit the inquiry to the face of the statute without looking into their other facts. Basically, you're not going to talk about the trust when it was revocable. We're going to talk about the trust when it became irrevocable. I believe that's what we're talking about. Court disagreed, blah, 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 but still found there to be insufficient contacts to create nexus for taxation. The court did not allow the state to use the residence of the beneficiary as relevant for the residency of the trust, as, quote, a trust is its own legal entity, y'all, with a legal existence that is separate from the grantor and the beneficiary, end quote. The trust is the taxpayer, not the beneficiary. Also, although the grantor was a Minnesota resident when the trust became irrevocable, and a Minnesota law firm prepared the trust, that was years earlier. Such acts, so the court said whatever year, and this is what I'm just picking up off of this, whatever year that S corporation stock was sold and you're trying to tax those profits, that's the year you got to look at when you're trying to create a nexus between the court. You can't say, it was Minnesota, it was set up by a Minnesota. None of that stuff matters. What matters is what's going on right now or in that taxable year very, very well. That's what's happening. Also, although the grantor was a Minnesota resident when the trust became irrevocable, a Minnesota law firm prepared the trust that was years earlier. Such acts cannot bind the trust forever to be subject to state tax and jurisdiction. Further, the court discussed the existence of a Minnesota S corporation holding Minnesota assets, but noted that corporate stock is an intangible asset and, in this case, was held solely by a trustee out of state. It's intangible and, first of all, it's intangible. Second of all, it was held by an employee out of state. A trustee out of state. Merely governing a trust under state law provides no contacts with the state until or unless the courts of the state develop a relationship with the trust. That fact was of no consequence. In the end, the court required the state to focus on contacts in the year at issue. Yep, that's what I'm saying. That year at issue was the year when that stock was sold and it hit that account. That's the year at issue. Not old historical facts. You can learn a lot reading this stuff. There simply were insufficient contacts with the state in the relevant year to serve as a constitutional basis for taxation. Then they got another one also very recently. And then there's some more. There's some more citations in here. But the power is in the lack of registration, y'all. The power is in the lack of registration. The power is in the lack of the trust being registered with any state. If the trust is not a creature of the state, if the trust isn't created by the state, if there is no state jurisdiction invoked in the contract indenture, as a matter of fact, if state jurisdiction is explicitly denied in the contract indenture, no state can pass any law impairing the obligation of contract. It's the Constitution, Article 1, Section 10, in part. And this stuff is powerful. If you know the claim, you can state a claim for which relief can be granted, y'all. So there it is. Zero court filings, total control. Why private trusts work. If you're interested in trustee training, hit the link in the description. You can also email me, start a dialogue. Closed mouth don't get fed. Don't be on no begging stuff. But everybody has a situation. We're more interested in the information getting out. Admin at welcometothefoundation.com. Sorry about the late show today. Doing my dance though. I trust y'all are doing your dance. And I trust you will enjoy yourself. Please take care of yourself. Make sure you say 10 things that you're thankful for before you go to sleep tonight and every night. It's very important. And I'll catch y'all on the next episode of The Foundation. My name is Sot L, Seeker of Truth L, Speaker of Truth L. Y'all enjoy yourselves. Peace, y'all.